Ladies and gentlemen, I'm Robert W. Matanke, president of the Decalogue Foundation and a past president of the Decalogue Society of Lawyers, the Jewish Bar Association founded in Chicago in 1934. Welcome to our presentation on the application of the rule of law in the war between Israel and Hamas. Today's program is sponsored by the Decalogue Foundation and the Decalogue Society of Lawyers and co-sponsored by the American Association of Jewish Lawyers and Jurists. We encourage you to support the Decalogue Foundation, a 501c3 charity, so that we can continue to provide legal and educational programming and scholarships to support the law and Jewish law students. I will introduce each of our panelists, and following their presentations, I will moderate a question and answer session. During the presentations, you can enter questions in the chat box so that they can be posed to our panelists following the question and answer, during the question and answer session. For those attorneys who have registered to receive the mandatory continuing legal education credits, please make sure that you complete the evaluation form at the end of the program, and also make sure you have your name on your screen so that we can identify you for purposes of compliance. Certificates of attendance for CLE credit will be emailed within the next few weeks. It is now my privilege to introduce Professor Jeffrey S. Korn, the George R. Killen Jr. Professor of Criminal Law and Director of the Center for Military Law and Policy at Texas Tech University School of Law. Professor Korn is also
Robert, you're muted.
I suspect I've been muted this whole time.
No, you said that I was the George R. Killen Chair of Criminal Law and Director of the Center for Military Law and Policy.
Thank you. At Texas Tech University School of Law. Professor Korn is also a distinguished fellow at the Jewish Institute for National Security of America's Gemunder Center and a member of that institute's Gaza Assessment and Hybrid Warfare Task Forces. He previously served as the Gary Cooper Distinguished Professor of National Security Law at South Texas College of Law in Houston. Prior to joining the South Texas faculty in 2005, Professor Korn served in the U.S. Army for 21 years as an officer, retiring in the rank of lieutenant colonel in 2004, and a final year as civilian legal expert on law of war matters. Professor Korn's teaching and scholarship focuses on the law of armed conflict, national security law, criminal law, and criminal procedure. His Army career included service in the Army's Senior Law of War Expert Advisor, Chief of the International Law for U.S. Army Europe, and Professor of International and National Security Law at the U.S. Army Judge Advocate General School. He earned his JD with highest honors from George Washington University and his LLM as the Distinguished Graduate from the U.S. Army Judge Advocate General School. He is co-author of 6 books: The Law of Armed Conflict and an Operational Perspective, The Laws of War and the War on Terror, National Security Law and Policy, Principles and Policy, U.S. Military Operations, Law, Policy, and Practice, National Security Law and the Constitution, and Law and War, a Concise Overview. Professor Korn has written numerous law review articles and has published in many periodicals and scholarly journals. Please join me in welcoming Professor Korn as he provides an overview of military law, its applications and obligations. Professor, the floor is yours.
Well, thank you, Robert, for the introduction. A special shout out to my former student I see on the screen, Travis Norman. Nice to see you, Travis, and I'm especially grateful for all of you who are taking the time to give me the opportunity to give you a little bit of perspective on the way international law functions to regulate what military lawyers call the conduct of hostilities in relation to the ongoing conflict in Gaza. Let me start by saying that 3 weeks ago, I spent a week in Israel as part of a assessment visit sponsored by the Jewish Institute for National Security for America, along with 3 retired U.S. flag officers, a 4-star admiral and 2 3-star generals, and had an opportunity to meet with Israeli military officials at every level of operations, including spending a day with the commander and staff of the 36th Armored Division, which was the first armored division or ground maneuver division to enter Gaza. And I just want to start by saying that the aspect of the visit that surprised me most was the scale of what military professionals call the combined arms maneuver operation in Gaza. And one of the points that I made to our Israeli counterparts is that I think they do themselves a disservice by consistently referencing a fight against terrorists. Because when people outside of Israel hear that, they think of a battle between a conventional military force and a group of loosely organized militants, when in fact what the Israeli Defense Forces confronted was a largely conventional enemy military capability. 36 battalions divided into brigades with areas of responsibility in Gaza. And I was really shocked to learn that at one point there were over 100,000 IDF ground maneuver forces conducting combat operations in Gaza. This was no small fight. This was no counterinsurgency operation. This was a conventional operation where combined arms maneuver forces, artillery, infantry, armor, attack aviation were given a classic operational mission, which was to close with and destroy your enemy through the use of fire and maneuver. That's what the Israeli Defense Force was doing and continues to do in Gaza. There are 6 battalions left that they have to deal with. And we know there's a lot of controversy over how they're going to do it because they're fighting an enemy that pervasively violates international law by embedding himself in the most densely populated civilian areas of Gaza. And the last area they have now is the Rafah area. And so the IDF is struggling with the challenge of how do we close with and defeat this enemy in a way that complies with our obligations to mitigate civilian risk. When ground or any military forces conduct combat operations, they are subject to what American military lawyers call the law of armed conflict, what most international lawyers call international humanitarian law, which is really the same body of law, which is the successor to what historically was called the laws and customs of war. So it's the body of law that does 2 principal functions. It regulates the conduct of hostilities, and it protects victims of war. The 2 branches of international law that regulate war are focused on those 2 principal functions. Many of you have probably heard of the Geneva Conventions. Those are 4 treaties that were updated in 1949 in the aftermath of the Second World War, originated in 1864 with the first Convention for the Protection of the Wounded and Sick. The Geneva Conventions really have nothing to do with how armed forces fight. They're all about protecting victims of war. There is a robust body of law that regulates how armed forces fight, and that's the framework that I'm going to focus on today. So I'm going to go over a number of what we would call core or foundational principles for the regulation of military operations and the conduct of hostilities. Let's start with the principle of equality of application. This is a widely misunderstood aspect of international law. All parties to an armed conflict are equally bound by the international legal obligations related to war, and that includes non-state organized armed groups. There's no disparity of application. Once you qualify as an armed group, you are organized and you engage in consistent or pervasive military operations, then you are bound equally to the same law that applies to the state armed forces you confront. Now, we know that doesn't mean there's equality of respect for the law. And if anything, this conflict is a iconic example of a disparity of respect for the law. You have one party to the conflict, the Israeli Defense Forces, that are committed to and as best they can respect international law. They're fighting an enemy that doesn't care about international law and actually uses the Israelis' respect for the law as a weapon against them. And Ord is going to talk a little bit more about that. But there should be no misunderstanding. Hamas, Palestinian Islamic Jihad, Hezbollah, they are all bound to the same body of law that applies to the Israeli Defense Forces. And the Israeli Defense Forces are bound to that law, even though they're fighting a non-state enemy. What matters is that you're in an armed conflict. An armed conflict is a contest between two or more organized armed groups. Whether they are state or non-state armed groups would be relevant when it comes to the treatment and status of captives. So, for example, you can only qualify as a prisoner of war with the benefits of being a prisoner of war and the protections if you are fighting on behalf of a state. But in relation to the way hostilities are conducted, all sides are equally bound. The first principle of military operations is the concept of military necessity. Now, for all of you lawyers out there, you understand that necessity is a principle of justification, and it applies no differently in theory in war as it does in peacetime. It justifies measures that otherwise would be prohibited because of the situation. So military necessity is a principle that's understood to justify all measures, and here's the important qualifier, that are not otherwise prohibited by international law, that are necessary to bring about the prompt submission of your enemy in the most efficient way possible. So basically what it means is every action that a military commander directs in combat has to be linked to the necessity of defeating the enemy. There has to be a logical link between that action and the necessity. But military necessity is not an absolute justification. By definition, it does not justify measures that are otherwise prohibited by international law. And that mainly has to do with how you treat individuals who are not actively involved in hostilities, civilians, detainees, prisoners. Military necessity does not justify torture. It does not justify cruel, inhuman, or degrading treatment. It does not justify summary execution. It does not justify hostage taking. It does not justify arbitrary deprivation of freedom or liberty, because all of those things are categorically prohibited by the law of war itself. What it justifies is combat measures that are not otherwise prohibited, that are necessary to bring about the submission of your enemy. Complementing, and not balancing, but complementing the principle of military necessity is the principle of humanity. And the principle of humanity may seem like an odd principle to apply in war, but it is inherent in the notion of military necessity. Essentially, if what you're doing is not justified by military necessity and it's going to cause harm or suffering, then it is inconsistent with the principle of humanity. The principle of humanity mandates that any person who's been detained or captured must be treated humanely. And that humane treatment specifically prohibits cruel treatment, degrading treatment, torture, physical abuse, incommunicado detention. In my view, there's an obligation to provide access to the Red Cross or some neutral third-party entity to verify the health and safety of the detainee. And it prohibits employing measures against your enemy that are calculated to inflict suffering beyond that which is necessary to bring about the enemy's submission, what we call the principle of unnecessary suffering. But in that regard, we also have to acknowledge that the law of war justifies a lot of necessary suffering. So using deadly force against your enemy is not prohibited. What would be prohibited would be using some weapon that was specifically designed to cause greater suffering to the enemy than was necessary to bring about his submission. For example, if you produced a weapon that had a fragmentation that was undetectable by X-ray or CAT scan, that would be considered inconsistent with the principle of humanity because it would prevent the wounded enemy from receiving some type of life-saving medical care. Now, once we get to the point of employing combat power, there are three critical principles that regulate the conduct of hostilities. And I will tell you that, in my view, the Israeli Defense Forces not only understand these principles, but they do about as good a job of implementing them as any professional armed forces in the world. That's not just my opinion. That's the opinion of every one of the generals or admirals that I've been involved with that have done observation studies of Israeli military operations in action. The first is the principle of distinction. The principle of distinction categorically prohibits directing attacks against civilians or civilian property that has not been transformed into a military objective. Notice that the prohibition is focused on the attack decision and not the attack outcome. That means anytime an enemy launches an attack directed at civilians or civilian property, that is a categorical violation of the law of armed conflict. It doesn't matter whether their effort was successful. So every one of the 10 or 15,000 rockets that Hamas has fired at Israel has been a violation of the law of armed conflict, because Hamas makes no pretense of even trying to attack a military target. They are trying to spread terror among the civilian population. That is their objective. That is a violation of the law. So the principle of distinction allows you to deliberately launch an attack, and I don't care whether it's a corporal with a rifle or a general with a air fleet at his command. It allows you to deliberately launch an attack only at three things: enemy personnel who have not been captured or rendered incapable of fighting by wounds, civilians who take a direct part in hostilities. The protection of civilian status is not absolute. If you choose to join the fight, do something that is causing direct and immediate harm to our forces, you forfeit your protection from being targeted. And the third are what we call military objectives. Military objectives can be anything. It can be a military base. It can be an airfield. It can be a bridge. It can be a mosque. It can even be a hospital. What is required is an assessment that the object or place has been transformed in a way that's making an effective contribution to the enemy military action, and its total or partial destruction will offer us a definite military advantage. So any of you have seen the movie Saving Private Ryan? You know there's that point in the movie where Captain Miller sends his sniper up to the church tower to do observation. By sending that sniper up to that church tower, which is a civilian object, was transformed into a military objective. A military objective is something that is transformed into military value by its nature, like an airfield, an enemy airfield, by its location. For example, a bridge, because of its location, can be a military objective. By its use, so if the enemy is using it as a military objective, for example, using a hospital as a command post would transform it into a military objective, or by its purpose. Purpose indicates future use. That's it. You may only deliberately attack one of those three things: enemy personnel, civilians taking a direct part in hostilities, or anything that is reasonably assessed as a military objective. Now, that doesn't mean you cannot inflict harm or damage on other people or objects. What it means is you may not deliberately seek to achieve that result. The law tolerates what we call incidental injury or collateral damage to civilians and civilian property, but it assumes that that incidental injury or collateral damage is a proximate effect of attacking a legitimate target. Almost all of the destruction and civilian harm that we have seen in Gaza has been the result of what we would call incidental injury or collateral damage, because it's the consequence of Israeli attacks on legitimate military targets. In contrast, every attack Hamas has conducted against Israel has not been an issue of collateral damage. It's been a violation of the more fundamental rule of distinction because they are actually trying to attack civilians. And if you don't take anything else away from my discussion, and I know there's a lot of information here, remember this: the law that regulates targeting, the decision to launch an attack, is not effect-oriented. We don't judge compliance with the law by looking at the consequences of an attack. We judge compliance of the law by considering the decision to attack. It's a conduct-based framework, not a result-based framework. And this is one of the most distorting aspects of the commentary on the conflict in Gaza. People look at the effects of the war and they say, oh, that must be a war crime because look at all the destruction. On the other hand, because Israel is effective in neutralizing Hamas rocket attacks, nobody pays attention to the fact that those attacks are launched against civilians and civilian targets. We need to focus on the attack decision, not the attack outcome. And while attack outcomes are relevant, they are almost never conclusive on the question of whether or not there's been a violation of the law. And that's especially true when you're dealing with an enemy that embeds himself among the civilian population and seeks to use the civilians to shield his targets, which is a violation of the law, or even worse, is trying to create conditions where the attacking enemy has no option other than to cause collateral damage and incidental death or injury to civilians. When that is a consideration, the commander has to consider what's called the proportionality rule. This is the most commonly cited criticism of Israeli operations, that they're disproportionate. So a couple of points. First off, the rule of proportionality has nothing to do with protecting the enemy target. The enemy target is a lawful object of attack. Proportionality is designed to protect civilians and civilian property that are proximate to the enemy target that will be killed, injured, or damaged as a consequence of attacking the enemy target. When a commander assesses that that is a risk, then the commander has to balance the anticipated military advantage against the anticipated civilian harm. And interestingly, the law does not use the word proportional. As civilian lawyers, I think we normally think of proportional as a close balance, 51% proportionality. The rule of law applicable to targeting uses the word excessive. So an attack is prohibited when the anticipated civilian harm is assessed as excessive in relation to the anticipated military advantage resulting from the attack. What is required is a substantial imbalance between the value of attacking the target and the risk to the civilian population. At that point, the commander is prohibited from launching the attack because it's considered indiscriminate. Now, you can imagine how hard that is to apply in practice. I could give you 50 hypotheticals, and with the number of participants we have in this briefing, we'd probably come up with 100 different answers as to whether or not it violated the rule of proportionality. It's not an irrelevant rule because it's a rule that reminds commanders that even in war, the ends don't always justify the means. There are some points where you should forego attacking an enemy target because of the risk to the civilian population. And I can tell you from my own interactions with our Israeli counterparts that there are many times where Israeli commanders make a decision to call off an attack because they make a judgment that the risk to the civilians is just too high. And that's their responsibility. That's not a lawyer's responsibility. That's a commander's responsibility. And finally, whenever you're conducting a military operation, you're obligated to take constant care to mitigate or reduce the risk or harm to the civilian population. In relation to launching an attack, this requires the implementation of what are called feasible precautionary measures. You must do everything feasible to reduce the risk to the civilian population without compromising your military advantage. Now, the word feasible is important here because it means two things. First, it means you have to have the ability to implement the precaution. If I don't have a printing machine, I can't drop leaflets because I don't have the ability to drop them. If I don't have aircraft to fly over the enemy territory, I can't drop the leaflets. So you have to have the capability to do it. But more importantly, feasible also means that using the precautionary measure will not compromise your anticipated military advantage. So I am not required to implement a precaution when doing so will compromise my advantage, and that includes increasing the risk to my own forces. Having said that, precautions are a ubiquitous aspect of IDF military operations, evacuations, temporary ceasefires to allow for evacuation, warnings by leaflets, by text message, by bullhorn, selection of weapon systems that are designed to mitigate civilian risk, efforts to verify the nature of the target and the risk to civilian population, collateral damage assessments, timing of the attack, considering alternate tactics in order to mitigate civilian risk. And in fact, in my view, and I've written extensively about this, I think this principle of precautions is the most important civilian risk mitigation principle in the law and is actually far more valuable than the proportionality rule. Because the proportionality rule, by definition, is amorphous. It's not clear, and it's got a lot of room for judgment. Precautions, on the other hand, are more aligned with the operational commander's instinct. Military commanders can figure out things like, can I change the time of the attack to reduce the risk to civilians? Can I use a different tactic? Is there a better weapons package that I can use? Can I issue a warning without losing my military advantage? And so these precautions are integrated into every aspect of attack decision-making, both in the US military and in the Israeli Defense Forces. And if we think about it, the more effectively you implement these precautionary measures, the easier it's going to be to do the proportionality assessment because you're driving down the civilian risk as much as is feasible. Now, ultimately, where does this leave us? This leaves us with a real irony. In Gaza, there is a conflict between two armed groups. There is one party to the conflict that is doing everything it can without compromising its military advantage, and I would say sometimes even with compromise to military advantage, to mitigate and reduce civilian risk. And there's another party to the conflict that is doing everything it can to target civilians and to increase the risk for its own civilians. And yet it's the side that's trying to mitigate civilian risk that is routinely condemned. And why is that? And I think one of the answers is because, number one, there's what I would call a bigotry of disparate expectations. There's this sense that if you're a professional military, we should hold you to the rules, but if you're fighting an unconventional enemy, they somehow are kind of released from their obligation. And as I mentioned, that's the flawed understanding of the law. And I think the other reason is because there's too much emphasis on the effects of combat and not enough emphasis on the process that is implemented to decide when, where, and how to launch attacks. Now, that may be inherent in the nature of the media and the visceral consequence of images, but it is a fundamental distortion of the law. And I think it's fundamentally unfair because you can have the best commander in the world who conducts an attack consistent with the law, who cannot avoid killing a civilian or destroying civilian property, who is condemned. And you could have the worst, most pernicious commander in the world that's trying everything possible to kill civilians and fails to do it, and we ignore that. And that's a perverse distortion of the way the law is intended to work. So I want to make sure I give my friend Ord plenty of time. So I'm going to cut my briefing off at this point, and I look forward to your questions after Ord is finished with his presentation. Thank you.
Thank you, Jeffrey, for this most informative presentation. I'm sure we could probably sit here for hours and still have many more to go, but I appreciate you being able to condense this into the 25 minutes or so that you spoke. And it's now my privilege to introduce Professor Ord Kittry of Arizona State University Sandra Day O'Connor College of Law and a senior fellow at the Foundation for Defense of Democracies. He is a leading expert on international law and policy, particularly as it relates to the Middle East, non-proliferation law and policy, and on U.S. regulation of international business transactions. Professor Kittry is the author of Lawfare, Law as a Weapon of War, published by Oxford University Press in 2016, which describes how and why law is becoming an increasingly powerful and prevalent weapon of war, and which provides examples of lawfare conducted by the United States, China, Israel, and the Palestinians, as well as non-governmental organizations and individuals. In 2021, Professor Kittry received the Serge Lazaroff Prize awarded by NATO Supreme Headquarters Allied Powers Europe for exceptional contributions to NATO in the legal arena. Prior to entering academia, Professor Kittry served for 11 years at the United States State Department, where he received the department's Superior Honor Award and its Meritorious Honor Award. At the State Department's lead nuclear affairs attorney, he helped negotiate the U.S.-Russia nuclear agreements and a UN treaty to combat nuclear terrorism. Professor Kittry also served as director of the State Department's Office of International Anti-Crime Programs, as well as the State Department's lead attorney for strategic trade controls and as a lead attorney for public affairs and public diplomacy. He also served as special assistant to the Undersecretary of State for Economic, Business, and Agricultural Affairs. Before joining the State Department, Professor Kittry served as legislative assistant and press spokesman for U.S. Representative Connie Marilla from Maryland. Professor Kittry has testified before various Senate and House committees and served on a special National Academies of Science committee to make recommendations on preventing nuclear, chemical, and biological proliferation. He has also testified before several state legislatures regarding divestment and other legislation related to foreign affairs. Professor Kittry's work has been featured in leading media outlets, including the Wall Street Journal, the Washington Post, and Foreign Affairs. He has done on-air commentary for networks and stations, including NBC, ABC, Fox, PBS, and Al Jazeera. He is also the author of numerous scholarly articles. He received his BA from Yale University and his JD from the University of Michigan Law School, and is a member of the Council of Foreign Relations. Please join me in welcoming Professor Kittry as he addresses the use of human shields by Hamas, the International Court of Justice cases filed against Israel, including genocide and illegal occupation, and the International Criminal Court proceedings regarding allegations made by Palestine against Israel. And now, Professor Kittry, the floor is yours.
Thank you very much. Hello, everyone. It's a pleasure to be here. Thanks to the Decalogue Society for organizing this. It's a particular pleasure to be on this panel alongside Jeff, who is, in my view, the best law of armed conflict expert out there. I also see a number of friends in the audience, including Eliza Lewin, who does fantastic work on campus issues as they relate to anti-Semitism and the law. As mentioned, I'm going to address how the various laws of war are being weaponized to wage lawfare against Israel and how Israel's allies are responding. I'll take a look at the UN and how it is mischaracterizing the law of armed conflict. I'll take a look at Hamas's use of human shields. I'll take a look at the 2 ICJ cases against Israel, and finally the International Criminal Court investigation of the Israeli-Palestinian conflict. So the first, the UN's mischaracterization of the law of armed conflict. What's the problem? For each of these, I'll give the problem and then what's being attempted in response. The problem is All of the charges against Israel are being amplified by utterly biased UN officials who use the imprimatur of the UN to make entirely false accusations against Israel. Three officials in particular, Navi Pillai and Maloon Kothari in the Israel-Palestine Commission of Inquiry, and Francesca Albanese as the Special Rapporteur for Palestine, are guilty of absurdly restrictive mischaracterizations of Israel's right of self-defense. They're guilty of exculpation of terrorist attacks and of false and inflammatory allegations of Israeli war crimes. These are a real problem. They combine to increase international pressure on Israel to leave Hamas in power, and they also set precedents that will hinder America's future ability to defend itself against terrorists. So what's the response? Israel and its allies are pushing back on the substance. In addition, the blatant bias of these three UN officials, both prior to their appointments and in their subsequent performance, means that their appointments were, and their service are, contrary to UN ethics rules. As I've written, along with my colleague Bruce Rashkow, who used to be the top ethics attorney at the UN, the appropriate remedy is to terminate the appointments of Pillai, Kothari, and Albanese. We've been pushing for that hard. We haven't succeeded, but our calls for their termination, which would be appropriate, hopefully have put some pressure on them and contributed to discrediting them. But the more that can be done to discredit them and point out their ethical violations, the better, it seems to me. I'll turn now to Hamas's use of human shields, how Hamas has weaponized the law of war against Israel. What's the problem? Well, Hamas hides behind human shields, and Israel gets blamed for the resulting casualties. Hamas has been doing this for years. They've engaged in the war crime of using civilians to shield their fighters and weapons from lawful attack. During this conflict, Hamas is illegally using both Palestinian and Israeli civilians as human shields. I'll give an example. A Hamas spokesman said at an October news conference, "We tell the people of northern Gaza and from Gaza City, stay put in your homes and your places." In this case, John Kirby, the U.S. National Security Council spokesman, correctly responded, "The Hamas counter order telling Palestinians in Gaza to stay at home means Hamas is using these civilians as human shields." Right? They're using civilians as human shields if they tell them to stay in their homes. Interestingly enough, this news conference in October was held at Shifa Hospital in Gaza City, literally using the hospital's patients as human shields. This has been a problem throughout this conflict. And indeed, Hamas has a long history of using Shifa Hospital as a military headquarters, and yet another violation of the prohibition on using human shields. The use of human shields creates a win-win situation for Gaza. If Israel holds back, Hamas gains on the battlefield in Gaza. If Israel attacks and inadvertently harms civilians, Hamas broadcasts the images far and wide, while falsely claiming that Israel uses force indiscriminately and is to blame for the casualties. So what is Hamas doing? Hamas is engaging in the actual war crime of using human shields in order to facilitate false accusations that Israel is committing war crimes, such as the willful killing of civilians. It's worth noting that this is a problem not only for Israel. The rampant use of human shields by NATO's adversaries has led the alliance's supreme allied commander for Europe, to whom I serve as an advisor. He's urged all NATO member states to impose sanctions and take other measures to counter the use of human shields. That's because the Taliban, the Islamic State, and others have been using human shields against NATO. So it's important to try to hold Hamas accountable for the use of human shields. This is easier said than done, unfortunately. Now, President Joe Biden, to his credit, has repeatedly and rightly condemned Hamas for using civilians as human shields. He's done it again and again in his speeches. There's U.S. federal law, which unfortunately expired at the end of 2023, which required the president to turn his rhetoric into action and hold accountable all complicit Hamas leaders operatives, and material supporters. This was the Sanctioning the Use of Civilians as Defenseless Shields Act, which was passed by both houses of Congress unanimously in 2018. The Shields Act specifically required the president to submit to Congress a list of persons the president determines to be involved in the use of human shields by Hamas or Hezbollah, and also for the president to impose sanctions on them. As I mentioned, the act unfortunately expired at the end of 2023. It needs to be renewed. In addition, what else can be done beyond rhetorically calling Hamas out for using human shields? Well, Hamas can be held accountable, and I'll get to this, at the International Criminal Court and also potentially in domestic courts. That brings me to the two International Court of Justice cases against Israel. You've probably seen in the news a lot recently. What is the International Court of Justice? The International Court of Justice is the international court, a part of the UN, that's designed to decide disputes between member states of the UN and also to advise UN bodies on the interpretation of international law. There are two cases against Israel there. One was brought by South Africa, accusing Israel of genocide, and the other was brought by the UN General Assembly, basically urging the International Court of Justice to determine that Israel must immediately withdraw from the territories occupied in 1967. First, I'll briefly address the South Africa case. On December 29th, South Africa baselessly generated an International Court of Justice case accusing Israel of genocide as it defends itself against Hamas. The International Court of Justice ordered preliminary measures, provisional measures, on January 26th against Israel. Mostly it ordered Israel to do things like comply with the Genocide Convention, which Israel was already doing. But South Africa has already twice requested amendment of the provisional measures against Israel. One set of amendments, which South Africa requested in February, was declined, and there's another set of amendments pending right now before the International Court of Justice. South Africa requested them on March 16th. Israel responded on March 15th, and I think we're going to see any day now the International Court of Justice's response. The U.S., the White House, accurately has called South Africa's submission of this case meritless, counterproductive, and completely without any basis whatsoever. This case is very important in its relationship with the human shields issue. Both South Africa's submission and the International Court of Justice's provisional order entirely ignored Hamas's use of human shields, right? They say, oh, Israel's committing genocide. Well, they entirely ignored Hamas's use of human shields and how that has increased the casualty figures. Then they use those casualty figures to justify preliminary measures against Israel. The problem, there's a problem for Israel, but also a problem for U.S. security more broadly. This tactic of making genocide charges based on casualty figures inflated by the use of human shields encourages the use of human shields by Israel's enemies and by America's enemies. Indeed, last month's ICJ order, as I've written, has undermined U.S. and allied security by creating incentives for terrorist groups and others to commit the war crime of hiding behind human shields. As I mentioned, ISIS, the Taliban, and others have used human shields against U.S. and NATO troops, as has Russia against Ukraine. These and other undemocratic actors are more than willing to commit war crimes and sacrifice civilian lives in order to accuse Western militaries, including that of Israel and the U.S., falsely of war crimes. And after last month's order, they'll be able to use these casualty figures to accuse Israel and potentially the U.S. of genocide. What is the response? Well, Israel is responding at the International Court of Justice with its filings. Israel's allies are pointing out South Africa's hypocrisy in doing this. Israel's allies are pointing out that South Africa is hurting relations with the United States by going after Israel. And in fact, Congress last week, the House Committee on Foreign Affairs overwhelmingly passed a bill calling for a review of U.S. relations with South Africa. And that bill threatens aid to South Africa. I would say that it is particularly ironic that South Africa has been complaining about casualties and about hunger in Gaza because the current South African government, as I've written in an op-ed recently, has looted billions of dollars from South Africa's state treasury. This corruption has left 8 million South African children hungry. Right? So they're complaining about the kids who are hungry in Gaza because Israel isn't feeding them sufficiently as Israel moves to defend itself against Hamas. Yet there are 8 million South African children hungry simply because the South African leadership has stolen billions from the South African treasury. In fact, there are 5.8 million South African children stunted due to malnutrition, due to the theft of billions from the South African treasury by the very South African officials who are making accusations against Israel. And all of South Africa's citizens, due to South Africa's corruption, suffer through daily power blackouts of up to 12 hours a day, days at a time without running water, and one of the world's worst performing school systems. So one of the things I've been particularly eager to do is South Africa makes these accusations against Israel with the halo, that comes from Nelson Mandela, who retired as president of South Africa 25 years ago. Nelson Mandela's successors have betrayed his legacy, and people need to understand that when South Africa accuses Israel of genocide and apartheid, this isn't Nelson Mandela doing it. What this is these entirely corrupt successors to him. So that's a response to South Africa's case. Meanwhile, separate case at the International Court of Justice, a UN General Assembly resolution passed, which requests from the International Court of Justice an advisory opinion that international law requires Israel to immediately and unconditionally withdraw from the territories it occupied in 1967, including the West Bank and East Jerusalem. The International Court of Justice accepted the case and recently held a week of hearings on it. Why is this a problem? Well, the other side's desired result of finding that Israel must immediately and unconditionally withdraw, no matter the risk to its security, would undermine Middle East peace efforts under the Land for Peace legal framework established by the Security Council and the Oslo Accords. Right, that framework is understood to be, what a peace deal would look like. Not Israel withdrawing unilaterally, but Israel needing to withdraw from those territories only in exchange for peace. Interestingly enough, the Arab Peace Initiative, approved by all Arab League member states, has explicitly endorsed the Land for Peace principle for countries like the UAE and Bahrain and probably Saudi Arabia. It's a matter of where those borders should be drawn. But ultimately, they are willing to give Israel peace in exchange for withdrawal. In contrast, Iran, Hamas, and Hezbollah have rejected Land for Peace and all other options for peaceful coexistence with Israel. What's the response to this ICJ case generated by the UN General Assembly? U.S. officials have criticized the proceeding as one-sided, and they are spoken in Israel's behalf. They're making filings. Another step that is being taken with regard to the International Court of Justice, and I did this in a Wall Street Journal op-ed about a month ago, is to point out that the International Court of Justice now has incredibly biased leadership. The current International Court of Justice president, Nawaf Salam, joined the court in 2018. He was recently promoted to president. He's twice been a candidate for prime minister of Lebanon. In one case, he was a candidate with the support of Hezbollah. So this is a guy who, while serving as a judge, has also been running for office. This is contrary to the ICJ charter. The ICJ charter also states that no judge may participate in the decision of any case in which he's previously taken part as advocate or in any other capacity. Yet Mr. Salam served as Lebanon's ambassador to the UN from 2007 to 2017, repeatedly denouncing and casting votes against Israel's military conduct and presence in the disputed territories. It seems to me he should recuse himself. I called for that, and I think we'll soon see a letter from members of Congress putting pressure in that direction. Finally, last but not least, we come to the International Criminal Court case about the Israel-Palestine conflict. The International Criminal Court prosecutes individuals for war crimes and other crimes against humanity. The US and Israel are not members of the International Criminal Court, but the Palestinian Authority is a member of the International Criminal Court. And the International Criminal Court announced in March 2021 an investigation into war crimes within the territory of the Palestinian Authority. What is the response? Obviously, Israel is mounting a substantive defense against these charges. The war crimes include war crimes allegations against the Palestinians, but also two categories of war crimes allegations against Israel. One category of war crimes allegations against Israel have to do with the use of force, the issues that Jeff Korn talked about, and the other category of allegations against Israel include allegations regarding the settlements, that the settlements are a kind of war crime. The worst case scenario is an indictment and an arrest warrant for Israeli officials. The International Criminal Court, sorry about that. The International Criminal Court recently issued an indictment and arrest warrant for Putin, and the South African leaders, for example, are calling for an indictment and arrest warrant for Netanyahu. How do we push back against this? Some of us have been both trying to defend Israel, but also making the case that the International Criminal Court could hold accountable Hamas's very top leaders for war crimes which have occurred after October 7th. So there's an effort to demonstrate that Hamas's very top leaders, including those in Qatar, who are maybe subject to more leverage than Hamas's leaders in Gaza, are responsible for war crimes. It's not so easy to show that Hania in Qatar ordered a particular rape or execution on October 7th, but it's actually not hard to demonstrate that Hania and the others in Qatar are complicit in the war crime of hostage taking. Right? Hamas continues to hold the hostages, and in my view, and I think the ICC is going to accept this, everybody in the entire Hamas leadership is clearly guilty of that war crime. We're also arguing that the US can prosecute the Hamas leaders in Qatar for these war crimes to the extent they were committed against US persons. But anyway, that's an overview of the several ways in which Hamas and its allies have been weaponizing the law of armed conflict against Israel. I'm happy to take any questions. Thank you.
Thank you, Ord. That was an enlightening presentation. Before I continue further, just for anybody who's come in late, I'm Robert W. Matanke, president of the Decalogue Foundation, a past president of the Decalogue Society of Lawyers, both of which are sponsoring this lecture today, along with a co-sponsor, the American Association of Jewish Lawyers and Jurists, and we thank them for their participation, and especially our joint board member officer, Michael Trayson, who helped facilitate that. I also want to acknowledge and thank Judge Mitchell Goldberg for having made the introduction to Ord Kittry, who brought in Jeffrey Korn, and I appreciate the participation of both of these erudite professors who are experts in their fields, as well as to thank Aviva Pat for all of the logistical arrangements she's made. And now we're going to open the floor for the questions over here, and I've received a whole lot of them in the chat. If you have questions, please post them in the chat. The first one is from David Weiner. If the enemy follows none of the rules of war and embeds against civilians and almost all of the international agencies are biased against Israel, why must they, Israel, so strictly follow those rules? Now, I'm not an expert in military law or in international law, but I think that the principle of two wrongs don't make a right is what applies. Professor Korn, is that the case?
I mean, there's the legal principle. The legal principle is clear. The enemy's violation of the law in no way releases you of your obligation to comply with the law. And in fact, if we allowed that, it would make victims of war double victims, because they'd be the victim of the pernicious and barbaric tactics of Hamas. And I agree with Ord on this issue of human shielding. I've actually written that I think there's a aggravated form of human shielding, and that's when we think of the word shield, we think of an effort to get the enemy not to attack. I actually think groups like Hamas want the Israelis to attack. They need the Israelis to inflict civilian casualties because, as one of the generals that I went on one of these projects with noted so insightfully, he said, when I was a young tank officer, I was taught that information supports combat operations. What I've learned about Hamas is that combat supports their information campaign. They're not going to defeat the Israelis on the battlefield. They're going to defeat them in the world of public opinion. And to do that, their ammunition is civilian casualties. So in my view, they are indirectly attacking their own civilians in many cases. But I think there's a more fundamental answer to your question, Robert. Very few people in the United States have served in the military today. Only about 2% of the population has experience in the military. I have a son he's a drone pilot in the Air Force. I don't want him operating under any commander who says, who cares about those civilians? Let's just kill them. That's immoral. The law serves a moral function. It provides lines that warriors have to abide by because they have to live with the consequence of the brutality of war that they are compelled to fight for a long time. And the law serves that function. So even if you're fighting an enemy that has complete disregard for the law, the suggestion that we should somehow discard our commitment to the law is morally corrosive and will harm not only good order and discipline, I think it will harm the moral integrity of the young men and women that are asked to fight the wars for our nations. And we can't forget that. I think the Israelis understand that intuitively, because so many of them have confronted the reality of war. And, if you're in this audience and you've never contemplated that another person could give you an order to take somebody's life, you ought to think about that for a minute, because that's not an easy line to cross. And when you have to cross that line, knowing that you followed rules that are accepted and embraced serves an important function. And even if the rest of the world condemns you, if you know that there are professional warriors out there who respect you for your commitment to the rule of law, even in battle, that serves an important function in enhancing morale.
Thank you. That also answers the next question that was on the list, because they can't win the war against Israel. They're trying to win a war of publicity showing civilian deaths that they're causing. And it's a crime. Going back to what Ord said about that, obviously the UN is biased, but we know that Ismail Haniyeh and Khalid Mashal have stolen billions of dollars from the Palestinian people. They know what's going on. They have done nothing else about it, certainly not to order the release of hostages. Where would they be prosecuted? what body would actually try to extradite them and hold them accountable for these actions?
Yeah, so I'm happy to take that one. They could be prosecuted in the U.S. I wrote a piece about this about a month ago. They could be prosecuted in the U.S., certainly for holding U.S. citizens hostage. That's the thing that they're clearly. I co-authored that piece along with Steve Pellak, a friend of mine who was a U.S. Department of Justice prosecutor for 20 years. And he was emailing me today saying, why has the Biden administration not yet? The Biden administration can announce the prosecution of Hania and the other leadership of Hamas and Qatar, and they can also request that Qatar turn them over for prosecution in the U.S. And this would be whether Qatar will in fact turn them over for prosecution, I don't know, but it's a way of putting Qatar on the defensive. You, Qatar, are harboring fugitives from justice in the United States. And frankly, it's also a way of perhaps putting some pressure on the Hamas leadership outside of Gaza to be a little bit more forthcoming in the hostage negotiations. If you basically make them think that they're going to spend the rest of their lives in a U.S. prison because they're holding hostages, maybe they will solve the problem by turning over the hostages. With regard to the other question that was raised in terms of why Israel doesn't start violating the law of armed conflict, first of all, yeah, I mean, civilian casualties are a form of ammunition for Hamas. So why would Israel want to increase the level of Palestinian civilian casualties? There's the question of internal Israeli morale. The Israeli boys and girls on the front lines want to think of themselves as wearing the white hats, which they do. And finally, I think support from the United States is dependent in considerable part on Israel being seen as wearing the white hat. And as long as you have experts on the law of armed conflict, former retired judge advocate generals, professors, and others like Jeff Korn saying, yes, Israel is doing its best to minimize civilian casualties. I think that's very important to continued Israeli support for Israel, which is not only political, but obviously ammunition and reinforcements of new weapons, et cetera, et cetera.
Can I just add one other point? Don't forget, Israel can prosecute these individuals as well. So individuals they've captured, if they have evidence that they were complicit in these war crimes, they committed them on Israeli territory. They're subject to Israeli law. They're also subject to military law. There's a possibility of using military tribunals to prosecute some of these individuals for war crimes. So there are a lot of options for prosecution. And some of the individuals, I think, are being investigated by Israel now for that type of action.
That would require an Adolf Eichmann type of kidnapping for Israel to get these two guys out of Qatar and bring them to justice in Israel.
For them, but there are thousands of detainees in Israel now that have been captured in this conflict, and many of them are complicit in war crimes and violations of Israeli law. There are going to be prosecutions in Israel. I have no doubt about that.
I'm sure of that. A question: if Israel follows the rules of armed conflict, then why does the U.S., the UN, and other countries constantly condemn them for civilian casualties, knowing that Israel makes great efforts to avoid it? Israel seems to be held to a completely different standard than the Palestinians and other countries at war. They are biased against Israel. I'm not sure if that's strictly a question or a frustrated response in a rhetorical form.
Or
But
maybe,
either of you would like to.
yeah,
Yes.
I mean, maybe the better question is, how do we as members of civil society push back against this? And look, there's an undeniable, as I said, bigotry of disparate expectations, right? Israel is held to a different standard, I even think, than the United States. I mean, if we look at civilian casualties in Rafah and Mosul that were inflicted, or in the Battle of Wei during the Tet Offensive, the ratio, it's absolutely stunning that we hear this condemnation of massive indiscriminate operations in Gaza, when even at the worst case scenario, if we take Hamas's numbers at face value, 31,000 casualties, which is probably not accurate, and we assume that every one of them is a civilian and none of them were enemy belligerents, which is not realistic, but okay, let's accept that. And then we take Israel's 14,000 enemy belligerents, that's their estimate of how many they've killed. Even the worst case scenario, that's a 1 enemy to 2 civilian loss ratio. And without being indifferent to civilian casualties, I defy anybody to find an urban battle of this magnitude where you had that low of a ratio between enemy and civilian casualties. Usually it would be something more like 1 to 10 or 1 to 15. So how that manifests the conclusion that Israel is conducting indiscriminate combat operations is just absurd. But what we're seeing here is the erroneous concept or the distorting consequence of what I mentioned before, effects-based condemnation. Look, it's easy to assign cause for a civilian casualty. You can look at who dropped the bomb that destroyed the building that killed the civilian. That's easy. But as lawyers, we all know that there's often a difference between cause and responsibility. The more fundamental question is who bears responsibility for the civilian casualty. And that's what we have to be emphasizing. Don't be so quick to assume that a civilian casualty that was the direct result of an Israeli attack is the responsibility of the IDF. In fact, the IDF may have done everything possible and feasible to avoid that consequence, and we should be pointing the finger of blame at the enemy they're fighting, who has complete disregard for its own civilians. And I think what Ord talks about, indicting some of these leaders, is, even if we never get our hands on them, is symbolically important, because we remind people that the true culprits in this conflict are the enemy that the Israelis are confronting. But it's an uphill battle, there's no question.
Yeah, and I just say, I just add to that what can be done? I think it's a combination. It's a combination of legal and political, right? I mean, what you do is you amplify the arguments of people like Jeff and myself that Israel is doing the right thing and the other side is not. And you also need to support your allies on this, right? Members of Congress who are supportive of Israel on these issues, who are accurately characterizing Israel as acting consistently with the law of armed conflict, be sure to support them. The other side has been doing a great job of protests in the streets and this sort of thing. And I think, there are more Americans, I think, who agree with us, but they're not being active about it. And I think it's important to be active about it. And I think it's important also, to reach out to pivotal decision makers like Joe Biden, who I think has been, certainly at the beginning of this conflict, very supportive of Israel. And he's getting hammered from the left of the Democratic Party. And, messages to him and to his allies, letting them know that we're watching and we care, and don't do this and do this. This is really important. So it's not just about arguing the law; it's also, frankly, political in terms of how to move the ball forward in terms of responding.
Those are good suggestions, and I hope that everybody on this call will follow up with whatever advocacy can be done. A question that was asked by Gary Starr: what is the significance of Ireland seeking to intervene in South Africa's case?
Oh, yeah, I don't think it's very significant. There are a lot of countries that have sought to intervene in South Africa's case, but ultimately, I think the key thing is that the case exists. South Africa, I think, has much more of a halo effect to it, or at least did, than Ireland does. So it seems to me what we're trying to do, and you can read my pieces on this, is set the record straight as to what South Africa is up to, point out South Africa's hypocrisy, and also send a message to other countries that might be following South Africa's lead that if you pull this kind of stunt at the International Court of Justice, which not only endangers Israeli security, but frankly, as I described, also America's security, that you're going to pay a price for it. And Congress last week voted overwhelmingly, the House Committee on Foreign Affairs, to review the U.S.-South Africa relationship. And that sent a very important message. I read the South African press, and boy, they all noticed. And the president of South Africa himself felt compelled to write an op-ed saying, oh, no, our relationship with the U.S. is not in danger because we're trying to hold Israel accountable. And the leading South African news site basically had two articles next to each other. One, this is what the South African president says, oh, we're not paying a price in the U.S. And the other was an article about the Wall Street Journal, which ran an editorial slamming South Africa and calling for sanctions against South Africa. So basically, the leading South African website responded to the South African president, said, I don't know, looks like people in the U.S. are noticing. That's really important. It sends a message to the South African people and to the South African leadership that there's a price to be paid for messing with Israeli and U.S. security.
Alan Sohn asked a question of what is Israel's obligation, if any, regarding humanitarian assistance?
Jeff?
So, yeah, so I mean, look, there's a legal answer and there's a pragmatic kind of strategic answer. What's the legal answer? The status of Gaza right now is extremely complicated. The law of belligerent occupation is a law that's designed to be kind of policy agnostic. When you displace a sovereign's control over territory by military force, then it's kind of like a bailment. You have responsibility to manage that territory. Of course, the problem in Gaza is Israel has not displaced another sovereign. I mean, the status of Gaza from inception has been complicated. As a practical matter, however, I think that there's a growing understanding, certainly within the IDF itself, that you can't allow a vacuum of chaos to emerge in Gaza. And if you have kind of functional control over a certain area, you bear certain responsibilities. This is not an issue of siege. I saw somebody put a comment up about siege. I've written about siege tactics. And siege is a complicated concept in and of itself because the law of siege really emerged at a time before many of the humanitarian rules related to civilian protection have evolved. Here's what I would say. If I were advising a military commander in Gaza, I would go back to that constant care obligation. And the constant care obligation is a simple rule. It says it's based on the premise that civilians, whether they're on your side of the border or the other side of the border, are all just victims of war. And so you have an obligation to do what you can that's feasible to mitigate their suffering. So, when we were in Israel, we talked to them a lot about this issue of humanitarian assistance and delivery. And the response was, we've opened up a lot of borders. It's not our responsibility to provide the humanitarian aid, which I agree with. It's an external responsibility. And there are a lot of international organizations that are trying to provide it. But we have to understand also that aid workers need some form of stability in the area they're functioning in order to facilitate the provision of that aid. And who's going to provide it? I think this is a dilemma right now that the Israeli government and the Israeli military are struggling with. Ultimately, what I think you'll see evolve is kind of a temporary occupation type presence where the Israeli military is going to be stuck. And I use that word, I emphasize it because it is. You're stuck with the mission of having to facilitate some type of public order in order to facilitate the provision of aid until they can hand it off to some other entity. And they haven't figured out who that is. By the way, there's a good report, again, from the JINZA, the Jewish Institute, from another group that did a report on how to deal with the day after the fighting, so to speak. But fundamentally, we know that you can rely on the law to say it's not my responsibility, but when the media shows images of children dying because they don't have access to food, water, or healthcare, it's a strategic disaster. And I think the Israelis understand that. And that's why you're seeing an increased effort to facilitate the provision of aid, even though it might not be legally obligated.
A question was posed with regards to the United States holding Al-Qaeda combatants at Guantanamo, and and whether or not that's a violation of the laws of war.
No, the first off there, I would, to be clear, in international law terms, they're not combatants. A combatant is somebody who is entitled to the legal privilege of engaging in hostilities. You have to be fighting for a state and you have to meet certain requirements. They're what we call unprivileged belligerents. So they're members of enemy organized armed groups who are not qualified for the legal privilege of participating in hostilities. They can be detained for the duration of hostilities. So the challenge at Guantanamo is we're fighting an enemy in a war that really is going to be almost impossible to figure out when it ends. And the United States view is that so long as we believe Al-Qaeda remains an ongoing threat to the security of the United States, then these high-level leaders are going to be subject to detention. And I would tell you that the Israelis would be legally justified in doing the same with Hamas operatives they capture until that threat has completely dissipated, even though they're not qualified as prisoners of war.
There was a suggestion recently by Itamar Ben-Gvir in Israel. Israel, as you know, I'm sure, has only executed one person in its history. Otherwise, the most horrible crimes are just life in prison. Itamar Ben-Gvir suggested that when Hamas combatants are captured and tried and convicted of war crimes, of mass murder from October 7, etc., that Israel should impose the death penalty. How would that correlate to the rules of law regarding war?
Well, the law of war doesn't prohibit the imposition of capital punishment, certainly by a military tribunal. The Military Commission Act that's applicable to people like Khalid Sheikh Mohammed and Ramzi bin al-Shid in Guantanamo authorizes capital punishment. They've been charged by the convening authority for Guantanamo with capital offenses. Now, I think ultimately they're going to end up pleading guilty in exchange for removing the death penalty. And my understanding is that under Israeli law, capital punishment could be legally imposed either by a conviction for the crime of genocide, which is interesting. The irony being Israel's been accused of genocide when you've got Hamas that has a stated purpose of genocide, or by a military tribunal for certain war crimes. And I think that so legally it would not be inconsistent with international humanitarian law or the law of armed conflict. I think as a policy matter, it's much more complicated for the Israeli government. And I'm sure that those are very complicated discussions that are going on right now. Are we going to seek capital punishment for some of the senior leaders we actually capture in this conflict?
So I'm glad you mentioned that about the charges that can be raised against Hamas, because Alan Sona had another question about whether it would be a good idea for counter anti-Israel propaganda by filing a counter complaint against Hamas in the, I'm not sure if he was saying the ICC or the ICJ, because he spelled ICG on his chat. I know on the ICC, Israel's not a signatory, so it couldn't do it.
No,
maybe Ord, what do you think of that?
Yeah, so you know, at the International Court of Justice, the International Court of Justice just deals with disputes between states. So can't really go after Hamas at the International Court of Justice. But at the International Criminal Court, in fact, the victims of Hamas atrocities are moving forward with submissions to the International Criminal Court. And my understanding is that the International Criminal Court is quite open to indicting Hamas members for the atrocities of October 7th, or potentially the hostage taking, which is easier to prove against the top leadership. I think the Israeli government isn't a party to the International Criminal Court, but they've made it clear that they also don't have the same hostility towards Karim Khan, the current International Criminal Court prosecutor. He's British, that they did towards his predecessor, Fatou Bensouda. And the Israeli government allowed Karim Khan to visit Israel for meetings with the hostage families. And the Israeli government is obviously not standing in the way of the families of the victims, most of whom are Israeli, as they present evidence. So I would predict that the International Criminal Court is, in fact, going to indict and issue arrest warrants for Hamas officials. It's obviously easy for them to issue arrest warrants and indictments for, those Hamas low-level operatives who are caught on video committing atrocities, but more challenging to go after Hania and others in Qatar, right? I mean, how do you show that they were complicit in a particular rape or a war crime on October 7th? But I suspect that you will see the ICC within the next couple of months issue arrest warrants for senior Hamas leaders, if only for the hostage taking, which is, as I said, the easier thing to prove that they're complicit in because it's really an ongoing crime.
Okay, I'm looking at the other lists of questions over here. Some of them are repetitive. One of them with regards to the whether or not the resolution that was passed the United Nations Security Council last week was binding. It was passed under a different article, so it's just a resolution, but it doesn't have a legal effect on Israel. And another question here from your student, your former student, Jeffrey, from Travis Norman. Is there any opinion or precedent by the ICJ, ICC, et cetera, that would prevent Israel from claiming right of self-defense as their justification for entering or responding to this current armed conflict?
Well, I think after October 7th, there was widespread international acknowledgement that Israel had a right to act in self-defense. There are some outlier views based on two International Court of Justice decisions that indicated that the right of self-defense under the Charter of the United Nations is only triggered when you are the victim of an armed attack by another nation. That, I think, is a discredited view. Actually, the first manifestation of that was the advisory opinion on Israel's building of a border barrier between Israel and Palestine, where the court held that Israel could not invoke the right of self-defense to justify that. The dissenting opinion by the U.S. judge on the court, Bergenthal, was really a tour de force because he emphasized, number one, that the United Nations the Charter of the United Nations in Article 51 does not limit the right of self-defense to an armed attack by another state. So in theory, there's no textual reason why a state could not defend itself against a non-state organized armed group. But more fundamentally, he noted that the weight of state practice had shifted so that there is a wider recognition that states do have a right to defend themselves against non-state organized armed groups. I don't think that's really the dispute. The real issue on self-defense is this claim that Israel's response is now excessive or over the top. And self-defense for a nation responding to an actual or imminent armed attack is really no different than the self-defense principles we all learned in law school. We're the victim of an unlawful armed attack or an imminent armed attack, and we're allowed to do what's necessary to restore our security. That's the real issue. And there's a real problem in the way this issue of self-defense is being discussed with this assertion of kind of you've done too much. Self-defense is not a tit-for-tat proposition. Self-defense allows a state to do what is necessary to eliminate an ongoing threat and restore the status quo of security. So I say this all the time, 2 points. Number one, when you hear people say that too many civilians have been killed, ask a simple question in response. Okay, tell me how many it was okay to kill. Because they can't answer that, because it's inherently arbitrary. The issue is what was necessary to restore Israeli security. The other point is, if you are the chief of staff of the Israeli Defense Forces and your prime minister said your mission is to ensure that Israeli civilians can return to their homes along the Gazan border, what would you need to do to go back to the prime minister and say it is now safe to return? To me, it's pretty simple. You have to destroy Hamas's combat capability. That's what self-defense justifies. The measures that are necessary to restore the security of the state against this ongoing threat. And you cannot define that by coming up with some arbitrary civilian casualty number. The justification of self-defense is not defined by the number of civilians you lost in the aggressive armed attack. It's defined by what is necessary to prevent the enemy from continuing that attack. And I think that's been lost in the discussion here with this emphasis of this aggregate number that the Palestinian Health Ministry just keeps pumping up, 20,000, 25,000, 30,000. It sounds awful. And again, I think it's a tragedy. People say too many civilians have died in this conflict. My view is one civilian was too many to die in this conflict, because this conflict never should have happened. And the only reason it happened was because of an unlawful act of aggression by a barbaric enemy that's determined to continue these actions if it's capable of doing so. So self-defense allows Israel to conduct a military campaign to neuter the capacity of Hamas to threaten its people across the border. And until that objective is achieved, the justification of self-defense continues.
Thank you. For people who are participating, you may have noticed we've run past the 1:15 hour in Chicago. We're actually going to be giving everybody 1.5 hours of continuing legal education credit for anybody who would like it. What I'm going to do is I'm going to let you all know, remind you that in order to get that credit, there's going to be a survey form that's going to be posted that you have to fill out, so that'll go back to Aviva, who's doing all the paperwork on this. And if it's okay with the speakers, with Ord and Jeff, I'm going to ask Aviva to unmute everybody. I don't know if we can do this orderly with 111 of us still remaining, but perhaps if you raise your hand digitally, I'll see if there's something you want to say in the next 3 minutes. We've got till 1:30, or whatever time zone you're in. Maybe it's 2:30 or wherever, because I think we have people from not just all over the United States, but also internationally. I'll open it up that way. Aviva, can you unmute? And then we'll let people raise their
I'm
hand.
not going to unmute everyone because there will be a cacophony that way, just background noise.
Okay.
But everyone now has the ability to unmute themselves.
Okay. And if you want to raise your hands, I'll be able then to recognize anybody whose hand is up if you have any follow-up questions. David Levitt, a former speaker at a program for Decalogue Society. By the way, I want to thank Eliza Lewin, who's participating also, who worked with her father on a presentation we did on a recent Supreme Court case. Thank you for being with us. As to all of the other participants, we thank you for your participation. David, a question.
Thank you. With all the talk about the Rafah operation and what the United States is saying, Rafah is right next to Egypt, and Egypt has closed its borders. Is there anything in the law of armed conflict or in international humanitarian law or other things that talk about the safety of refugees and the acceptance of refugees, one way or the other, in order to protect them during the armed conflict for other countries nearby?
No, there is no international rule that says you must open your borders to enable civilians to avoid the consequences of conflict. International law would apply once someone crossed that border if they claim refugee status, but you don't have to let them in. This is more of a political kind of strategic issue. It also, David, it cuts another way as well. I mean, you could ask the question, should Israel have created some safety zones on its side of the Gazan border, and they didn't have an obligation to do that either. So, I mean, the sad reality is the IDF is going to have to figure out how to maximize the evacuation of those civilians before it closes in on those final 6 Hamas battalions that are clinging to their combat capability in that area.
We have 3 more questions. I'm going to cut it off on this because we're going to be 1 minute till we close. Let's short question, short answer. David Charles Silberman was first.
Thank you. What particular significance do the captives have for what Israel can legally do? And why isn't the American media stressing the possible ongoing rape and torture of the Israeli captives?
Well, on the media question, I mean, I think that's a frustration we all probably share, that there's a, you know, there seems to be, people have a short memory of the suffering of hostages. In terms of the impact it has on Israel's capacity to operate, it obviously complicates combat action because you're trying to fight an enemy that's hiding behind your own civilian hostages now. And we know there have been some tragic incidents where hostages have been killed by combat action, but ultimately that's more of a tactical, operational consideration than a legal consideration.
Enid Zimmerman.
Thank you very much, and fantastic discussion and presentation. Are we doing Israel a significant disfavor by calling this a war rather than an armed conflict, given the fact that there is no recognized country of Palestine, while we may have a different discussion about
I mean,
nationals?
Yeah, I don't think so. I mean, the term armed conflict is simply a legal term was developed to make sure that nations couldn't avoid their international legal obligations by saying the conflict didn't meet the international definition of war. I actually think it's the opposite, which is the point I made earlier. We don't emphasize enough the gravity of the Hamas capability and the gravity of the threat that Israel had to confront when it closed with that enemy in combined arms combat operations on the ground in Gaza. I think most external observers think it's this uber powerful Israeli military against a bunch of guys throwing Molotov cocktails. They don't really understand that this is a bona fide war. 100,000 ground troops to close with and defeat this enemy was not a counterterrorism operation. It was a war. And that's what the Israelis have been dealing with. It's going to evolve into an insurgency, and they know that. But they have to get to the point where Hamas's conventional capability is completely neutered. And I think we do a little bit of disservice by not emphasizing the gravity of the threat that they actually faced was not just a counterterrorism threat.
Under international law, are funders of Hamas considered combatants, part of the war? So Iran, potentially Qatar.
Well, I
others?
mean, whether they are co-belligerents is a different, more complicated question. Combatants, no. Providing resources to an enemy armed group doesn't make you a target of attack. It doesn't forfeit your protection as a civilian. So generally, no.
Last question, David Weiner. Thank you, Ina.
Yeah, this is about the Philadelphia corridor. I mean, given the volume and the size of the weaponry and machinery that's found in Gaza, it's my opinion that the huge majority that comes through Egypt who's either unwilling or incapable of stopping it, and there are massive tunnels throughout both sides of Rafah. What is the law on Israel taking a swath of Rafah, the Philadelphia corridor, and digging deep and trying to stop those tunnels in between Egypt and the Egyptian side and the Palestinian side?
Yeah. So that would implicate a doctrine of international law that the United States has relied on quite heavily, called the doctrine of unable or unwilling. And the theory is when there's another state whose territory is being used by a group that's threatening you, and they are unable or unwilling to prevent that threat, then you have a right under the law of self-defense to take self-help action. So I think, David, you could make a legal argument But as a matter of strategy and policy and politics, I think the Israelis recognize it would be a disaster to go into Egyptian territory without Egypt's consent. And so my understanding from the meetings we had when we were over there is they are figuring out ways to neutralize those corridors from the Gazan side of the border without having.
That's what I meant, the Gaza side.
Oh yeah,
Not Egypt, not Egypt.
No,
Not Egypt.
that is part of the operational objective of disabling Hamas's capability to continue to threaten you. They are going to conduct, they're going to execute a lot of missions along that border to make sure that those corridors are sealed off as much as possible.
But I mean, occupying that land, maybe 1,000 yards, 500 yards, and just dig down.
I think it's likely you're going to see that. You're going to see an Israeli military presence along that border for a long time.
Okay, thank you.
Thank you. Thank you very much. Ina, with response to your last question, by the way, we hosted Nitzana Darshan Leitner, who founded an organization called Shurat Hadin, and she uses civil actions to claim damages against people who support terrorism. And you might want to follow up with her and her organization. The survey has been posted, so everyone please fill out the questions so you can get your CLE credits. And while you're doing that, I really want to thank our professors, Ord Kittry and Jeffrey Korn, for an absolutely fantastic presentation. I learned a lot. I'm sure everybody else did also. And mostly that we have to continue with our advocacy and try and get the word out that Israel is doing the right thing and the necessary thing, and try and see what we can do to relieve some pressure and get the U.S. government to assist in other ways. I thank you all for participating from all the organizations that you've come from, especially from the American Association for Jewish Lawyers and Jurists. It's a bar association that operates similar to, I'm not sure who's talking, but it's similar to the Decalogue Society operating in the East Coast. Not as old as we are. We were founded 90 years ago. But we look at law as it relates to issues that affect the Jewish lawyers, the state of Israel, besides the other things we present on our regular CLEs for the bread and butter type legal topics that attorneys need to be up to date on. I invite you to support the Decalogue Foundation, as I said before, a 501c3 organization, as well as have membership in the Decalogue Society and the American Association of Jewish Lawyers and Jurists. Once again, I thank everybody for their participation, especially our panelists. And I look forward to our next event, and we'll let you know as soon as we get a topic and world-class speakers. Thank you all.
Thanks, Robert.
Thank you.
Thank you.